telephonic hearing in the matter of the application of Dominion Energy Utah for approval of funding for the Intermountain Industrial Assessment Center. That's Commission Docket number 19-057-33. My name is Michael Hammer, and I am the Commission's designated presiding officer. Let's go ahead and take appearances from the parties, beginning with Dominion Energy, please.
Thank you. This is Jennifer Clark. I'm counsel for Dominion Energy, and I have with me Kelly B. Mendenhall. He will be providing a summary of the stipulation and the company's position as it stands today.
Thank you. And from the Division of Public Utilities.
Good morning. This is Patricia E. Schmid with the Attorney General's Office, representing the Division of Public Utilities. Robert A. Davis is the division's witness today, and he will provide testimony in support of the settlement stipulation filed July 16th, 2020. Thank you.
And from the Office of Consumer Services.
Good morning. Victor Copeland, Special Assistant Attorney General with the Office of the Utah Attorney General, representing the Utah Office of Consumer Services, which I will refer to as OCS. OCS intends to call one witness to present evidence to explain and support the settlement stipulation, specifically utility analyst Bela Vashtag.
Thank you. Is there anyone else on the line that intends to have a speaking role in today's hearing? All right, Ms. Clark, please go ahead and call your first witness.
Well, I do have one preliminary matter before we call witnesses, if that would be all right with you.
Of course, I'm sorry.
No, that's fine. I would draw your attention to paragraph 19 of the settlement stipulation, which provides that the parties agree that all pleadings, comments, and action request responses can be admitted as evidence. Having discussed it with some but not all of the other parties, the company believes we also intended that pre-filed testimony be admitted as evidence. And I would simply, based on that paragraph, move for the admission of the company's pre-filed amended application, along with the direct testimony of Mr. Orton, Dr. Powell, and Mr. Mendenhall, and their accompanying exhibits as well.
Any objection from the DPU?
No objection.
Mr. Copeland?
No objection from OCS, and just for purposes of clarity and completeness of the record, OCS would further move that the Commission receive the direct testimony of Bela Vashtag that was dated June 15th, 2020 into evidence as part of that motion.
I expect there's no objection, Ms. Clark.
No objection.
All right,
If I may
then all of the pre-filed. Go ahead, Mr.
Thank you. Testimony of Dr. Powell, referenced by Ms. Nelson Clark, refers to the direct testimony of Cody M. Powell, who's associated with the University of Utah, not the testimony of William A. Powell, who commonly testifies for the division. Our Dr. Powell did not provide testimony in this docket.
That's
Understood.
correct. And perhaps I could just recite by exhibit number for clarity of the record. The company would move for the admission of the amended application, along with the amended direct testimony of Michael A. Orton, which is marked as DEU Exhibits 1.0 through 1.02. We would also move for the admission of the direct testimony of Dr. Cody M. Powell, which is marked as DEU Exhibit 2.0. And we would move finally for the admission of the direct testimony of Kelly B. Mendenhall, which is marked as Exhibit 3.0, with accompanying exhibits 3.01 and 3.02.
All right, for clarity, there's no intention to exclude any of the written pre-filed testimony in the docket from evidence, correct?
Correct.
All right, then we'll consider and deem all of the pre-filed written testimony as admitted. Is there any other preliminary
Thank you.
matter before we begin with testimony?
None from the company.
Go ahead, Ms. Clark.
Thank you. The company would call Kelly B. Mendenhall.
Mr. Mendenhall, do you swear to tell the truth?
Yes.
Thank you.
Mr. Mendenhall, will you please state your full name and business address for the record?
Yes, my name is Kelly B. Mendenhall, and my normal business address is 333 South State Street, Salt Lake City, Utah.
Mr. Mendenhall, what position do you hold with the company?
I'm the Director of Regulatory and Pricing for Dominion Energy, Utah.
And Mr. Mendenhall, did you participate in the preparation of the application in this matter, as well as the drafting of the settlement stipulation that has been filed in this docket?
Yes, I did.
Can you please summarize that settlement stipulation and the company's position?
Sure. So it might just be easiest to walk through some of the key terms and conditions. So why don't we if we can turn to page 3 of the settlement stipulation, beginning paragraph 7. And while you're turning there, I just want to thank the Division of Public Utilities and Office of Consumer Services for their work on this stipulation. There was a lot of time getting these conditions right, so I appreciate their collaboration. So on page 3, paragraph 7, it basically just says that those parties I just mentioned, the division, the office, and Dominion Energy Utah, bring this settlement before the commission. If we move on to paragraph 8, we have agreed to a funding amount of $500,000 per year for a 2-year pilot period beginning October 1st of 2020. And just to give you an idea of the impact that would have on our typical customer, it would be about 35 cents a year or 0.05% increase in a typical customer bill. And so the total amount would be, as I mentioned, $500,000 per year for 2 years for a total funding of $1 million. And we've also provided confidential Exhibit A, which provides a breakout or summary of how that funding will be used for the IAC's program. Moving on to paragraph 9, this talks a little bit about the deliverables. And so as part of the program, the IAC will perform 40 assessments, energy assessments with associated clean air analyses on these customers. And we're really hoping that this will act as a project generator to help identify measures that we can bring before the commission as separate step projects. So they will perform those 40 assessments, and then they already have a very successful DOE related program. We'll be able to leverage that program, and they'll perform 40 clean air analyses on those projects as well. So over the 2-year period, we'll have 80 potential candidates that we can look at to generate projects. This paragraph also talks about how the funding will be dispersed. So it'll be $100,000 per quarter for 8 quarters. And additionally, there will be 2 performance payments. The first will be paid out after 16 assessments have been completed. The second will be paid after all 40 assessments are complete for the 2-year period. There's also a clause in this paragraph that talks a little bit about COVID-19, and parties recognize that if, or due to the pandemic, the energy assessments can't be performed, we have the ability to press pause on the program. And if we do that, we will notify the commission that that is occurring, and then we'll resume when it's practicable. Moving on to paragraph 10, this talks about potential additional funding. So if after 20 months, the company, after evaluating the program and the work performed and the results achieved, determine that additional funding is warranted, we have the ability beginning May of 2022 to come in and ask for additional funding And this just lays out the timeline of what that would look like in a proceeding before the commission. Moving on to paragraph 11, we've identified some pre-screening criteria that the company and the IIAC will use to determine what customers will qualify for a potential assessment. And so just to give you kind of a highlight list of what those are, the first, the customer's usage or aggregate usage for multiple customers would need to exceed 2,500 decatherms per year. That's basically, the larger the customer, the greater the potential they have to improve air quality. So we're really hoping to get some of these bigger customers involved. They will also need to be a Dominion Energy customer currently. They will need to be willing to participate in an implementation review, and also to be identified as a program participant. And if they are involved in receiving additional STEP funding, their name will need to be shared as a recipient. And then we're also hoping that they've not had a prior assessment done for their business. Moving on to paragraph 12, this talks about the guidelines that we've developed to help guide to those in a lot of detail, but I will tell you that they're attached in Exhibit B, and they cover 4 areas. They cover assessment process and performance, assessment reporting, assessment recommendations, and then the last one is employment of student personnel and conducting assessments. And the DOE, with their relationship with the IAAC, has very similar guidelines. And so we actually used their guidelines as kind of a boilerplate to start with to help us to develop these. But this will give both the DEU and the IAAC some guidance on how the program will be administered. Moving on to 13, this just provides some clarity on how the funds will be used. We will not use the funds for scholarly publications or related presentations and travel. Moving on to paragraph 14, this just basically says that any measures that are identified by the IIAC that are brought before the commission for additional STEP funding will be related to natural gas operations. So, for example, if they do an energy assessment and they find a potential measure that would save electricity consumption and improve air quality on that side, we would not bring that project before the commission. Obviously, Rocky Mountain Power would have the opportunity to, but under our program, we would not be seeking STEP funding for those measures. And last, paragraph 15, just talks a little bit about the reporting. So we will provide quarterly reports to the office and division, and we will develop exactly what those reports look like. They will include things like detailed budgets, the impacts of COVID-19, and assessment and analysis results. And then annually, we plan to file with the commission a summary of that information that we provided quarterly to the division and the office. Additionally, in our reports, we will provide information on our outreach to other universities and opportunities that we've given them to participate in the STEP program. And then finally, we will talk about our promotional and marketing efforts. Our goal here is to cast a wide net to get a diverse group of customers, both in terms of type of customer as well as geographic area. And so we'll report on both the marketing efforts and the makeup of the customers that are participated. So there were 2 items that we did not address in the stipulation, but I did address in my testimony, and I just want to touch on those really briefly. And we didn't include them in the stipulation. That was probably an oversight on my part. The first was related to the creation of a balancing account. So in my testimony, I proposed that we would create a balancing account to manage these funds. And the division office, and I don't believe they discussed it in their testimony, but I just wanted to point out that the STEP statute gives some guidance on this, and the STEP statute in Utah Code 54-20-105, paragraph 3E, states that a large-scale natural gas utility shall establish a balancing account that includes funds allocated for projects that have been approved by the Commission under subsection 3A, which is what we're proposing to do here today, and also include a carrying charge in an amount determined by the Commission. So if the Commission approves this settlement and the funding, the company plans to establish a STEP balancing account and would use the carrying charges approved in section 8.07 of its tariff. The other issue I raised in my testimony that is not addressed in the stipulation is the tariff language. I proposed some tariff language associated with this balancing account, and discussed a little bit with the other parties about how to handle this, and they'll have an opportunity to speak, obviously, so I don't want to put words in their mouth. But assuming the Commission approves the stipulation, the next step for us, the company, would be to file a STEP surcharge filing to actually begin charging customers, and we would contemplate that at that time we would incorporate this tariff language related to the balancing account in that filing, and that would give parties a chance to weigh in, and we can resolve it in that proceeding. So I think we don't need to deal with it here today. So just wanted to point those two things out. So to summarize, the company believes that this settlement is just, reasonable, and in the public interest, and we respectfully request the Commission approve the settlement. And that concludes my summary. Thank you.
Mr. Mendenhall is available for cross-examination and also questions from the Commission.
Ms. Schmidt?
The division has no questions for this witness. Thank you.
Mr. Copeland?
Thank you. I have just one minor clarifying question. Mr. Mendenhall, in providing a verbal summary of the terms and conditions in the settlement stipulation, and except for the balancing account and tariff language you just mentioned, it was not your intention to conflict with, change, or otherwise modify or inform the interpretation of the written terms of the settlement stipulation in any way, correct?
Correct.
Thank you.
And you resolved my only question, Mr. Mendenhall, which concerned the carrying charge. So thank you very much. Ms. Clark, do you have any other witnesses?
The company has no other witnesses. Thank you.
Ms. Schmidt?
Thank you. The division would like to call as its witness Mr. Robert A. Davis. Could he please be sworn?
Mr. Davis, do you swear to tell the truth?
I do.
Good morning. Could you please state your full name, employer, title, and business address for the record?
Yes, my name is Robert A. Davis. I work for the Division of Public Utilities as a utility technical consultant. My business address is 160 East, 300 South, Heber Wells Building, 4th floor, Salt Lake City, Utah, 84114.
In connection with your employment by the division, have you participated on behalf of the division in this docket?
Yes, I have.
Do you have a statement that you would like to present to the Commission today?
Yes, I do.
Please proceed.
Good morning. Dominion Energy of Utah requests the Commission's approval of its application to fund the University of Utah's Intermountain Industrial Assessment Center, IIAC, under Utah Code Section 54-20-105 of the Sustainable Transportation and Energy Plan Act, or STEP. The funding provides for a 24-month IIAC pilot program to begin October 1st, 2020, at a funding level of $500,000 per year for a total of $1 million in IIAC funding during the pilot program period. In return, IIAC will conduct and complete 40 assessments, including clean air analysis and an additional 40 clean air analysis on IIAC Department of Energy related projects during the 24-month pilot program. Dominion Energy Utah has agreed to provide quarterly and annual reports on the progress and status of IIAC in a format agreeable to the parties. The division concludes that the IIAC pilot would be useful to aid Dominion Energy Utah customers to find efficiencies in their processes, buildings, and plant facilities that may lead to the conservation of energy and reduce pollution. Therefore, the division finds Dominion's request to fund the Intermountain Industrial Assessment Center under the STEP Act in the public interest and recommends the Commission approve the 24-month pilot as stated in the stipulation between the parties. That concludes my summary. Thank you.
I have just two follow-up questions. Is it the division's testimony that the stipulation is just and reasonable in result?
Yes.
Is it also the division's testimony that the evidence contained in the record, including the testimony presented today, supports a finding that the settlement proposal is just and reasonable in result?
Yes. Yes.
Thank you. Mr. Davis is now available for cross-examination questions and questions from the hearing officer.
Mr. Copeland?
No questions. Thank you.
Ms. Clark?
The company has no questions. Thank you.
And
The
Mr.
division
Davis?
has
I'm sorry, I had a little bit of audio trouble, and if you covered this and I missed it, I'm terribly sorry. But did you speak to the issue concerning the carrying charge that Mr. Mendenhall spoke to in his testimony?
I did not.
Okay. Does the division have a position on that?
Mr. Davis, do you agree that the process proposed by Mr. Mendenhall today is acceptable to the division?
Yes.
Okay, thank you. No other witnesses, Ms. Schmidt?
Thank you. No, the division has nothing further.
Mr. Copeland?
Thank you. OCS calls Bela Vashtag and asks that he be sworn.
Mr. Vostog, do you swear to tell the truth?
Yes, I do.
Thank you.
Mr. Vashtag, please state your name, employer, occupation, and business address for the record.
Yes, and I'll spell it for the court reporter. My name is Bela, B-E-L-A, Vostag, V-A-S-T-A-G. I am a utility analyst, and I work for the Utah Office of Consumer Services. My business address is the Heber Wells building, which is at 160 East, 300 South in Salt Lake City, Utah.
Thank you. And Mr. Vashtag, in your capacity as utility analyst for OCS, have you worked on OCS's filings in docket number 19-057-33? And are you otherwise familiar with the record in that docket?
Yes, I have worked on it, and I'm very familiar with it.
Thank you. And have you read and did you participate in the negotiations and drafting of the settlement stipulation filed in docket number 19-057-33 on July 16th, 2020?
Yes, I have.
Thank you. Is it OCS's position that this settlement stipulation, taken as a whole and if approved by the Commission, would be a just and reasonable result and in the public interest?
Yes.
Thank you. Have you prepared a summary of OCS's position with respect to this settlement stipulation?
Yes, I have.
Please proceed with your summary.
Thank you. Good morning, everyone, Commission. The settlement stipulation before the Commission today provides for funding of the Intermountain Industrial Assessment Center, or IIAC, under the Sustainable Transportation and Energy Plan, or STEP, Act. Prior to the filing of this stipulation, the Office of Consumer Services, or OCS, in our June 15th, 2020 testimony in this docket, raised several issues and concerns about Dominion Energy's proposed use of ratepayer-provided STEP funds for the IIAC. A summary of our issues are as follows. One, the initial funding for the IIAC should only be for a pilot period in order to determine whether the IIAC approach is feasible, cost-effective, will deliver benefits. Two, funding during the pilot period should be significantly less than the $2.4 million requested by Dominion Energy in its application. Three, before STEP-funded IIAC work would begin, Dominion should establish criteria for the pre-screening and the evaluation of projects. Four, the IIAC should have guidelines governing how it conducts its work under the STEP program. Five, a budget should be provided that shows with adequate financial detail how the IIAC proposes to spend STEP funds. Six, the IIAC should have specific goals and measurable deliverables, such as the number of assessments and the number of air quality analyses done over a certain time frame. Seven, Dominion Energy should provide quarterly reports on the IIAC's progress to the OCS and the Division of Public Utilities during the pilot period. Eight, because public funds are being spent, certain information for each STEP-funded project should not be designated as confidential, but should be made available to the public. Nine, the IIAC is part of the University of Utah, and Dominion Energy should offer other Utah universities the opportunity to participate in DEU's STEP program. 10, and finally, because the COVID-19 pandemic will most likely have some impact on how the IIAC operates, Dominion Energy should report on these impacts and, if it is necessary, to temporarily suspend IIAC operations and STEP funding due to COVID-19 restrictions. The OCS, as discussed earlier, the OCS has participated in several settlement negotiation meetings and was very involved in the development of the stipulation now before the Commission. The OCS believes that this stipulation adequately addresses the issues and concerns that I just outlined in this statement and that I discussed in detail in my June 15th testimony. The OCS feels that addressing these issues is important to prudently manage the expenditure of ratepayer-provided funds. Therefore, the OCS believes that this settlement stipulation is just and reasonable in result and in the public interest. The OCS recommends that the Commission approve it. And then finally, I wanted to also state, if the Commission approves the settlement, the OCS also supports Dominion's proposal to establish a STEP balancing account and to address the STEP surcharge, carrying charge, and associated changes to tariff language in a future filing before the Commission. That concludes my statement.
Thank you. Mr. Vashtag is available for cross-examination and for questions from the Commission.
Ms. Clark?
The company has no questions.
Ms. Schmidt?
The division has no questions.
And I have none. Thank you, Mr. Vostok. Anything else, Mr. Copeland?
No, thank you.
All right, is there anything else from any other party before we adjourn?
Nothing more from the company.
Nothing more from the division.
Nothing from OCS.
Well, thank you everyone for your participation this morning. We're adjourned.
Thank you.